official holiday from the date of service on you of this notice. Excluding Saturday, Sunday holiday is without except of this notice, or to vacate and surrender possession of the premise. In the event you fail to do so, legal proceeding will be instituted against you to recover possession of the premise. Declare the forfeiture of the rental agreement or lease under which you occupy the premise and recover rent, damage, and cost of suit. Rent is to be paid to undersigned or the following person. Rent who you pay the manager or landlord at the following address, manager address or landlord address, in the following manner: in person meaning directory, user date and hours for rent collection are something, by mail to the person and the address indicated above. Every month send by mail to the rent. Third one, by deposit to account, some bank account or some any place at bank name, financial institution locate 5 miles of your rental address, something. By election funds transfer for this procedure, previously estimate, date, landlord, something. Proof of service. The undersigned, being at least 18 years of age, any legal action, age is over 18 years. 18 years of age, service this 3-day notice and notice of which this is true copy on something, name, one of the occupants listed above as follows. Landlord or manager drop this paper, how he can send it. This person, drop person. On date, I delivered a notice to the occupant personally. On date, I delivered the notice of the paper of assurable age and discretion at the occupant, tenant, resident, business, after having attempted the personal service at the occupant's residence and the business, if known, on some date. I mailed the second copy of the occupant at his or her residence. I posted the notice in a conspicuous place on the property after having attempted personal service at the occupant's residence and business, if known, and after having been unable to find their person of assurable age and discretion on date, I mailed second copy of the occupant at his or her residence. I declare on the penalty of perjury under the laws of the state of California that is foregoing is true and correct. Date, name, and signature. This is 3-day notice. Sometimes it's California 6-day lease termination notice. 6-day. Why? Sure, 3 days. But this person is a 6th day. 6 days reason they don't have any lease paper doesn't have any newspaper, 60 day or 30 day. 60 day, notice the landlord election to terminate your tenancy, which is defined as the hiring of real property under the California Civil Code due to your tenancy lasting for 1 year or longer. The notice period of 60 days meet the statutory requirement. Tenant name, which include any other residents, occupants, or individuals on the premise. Property address, premise, lease date, start date, the last date on the premise. Premise meaning property. Exempt from the Tenant Protection Act of 2019, check 1, yes. The notice is exempt to the Tenant Protection Act, or no. This notice is not exempt from the Tenant Protection Act. Therefore, you are entitled to relocation assistance equal to 1 month's rent. Which rent will be provided to you no later than the termination date, or you will receive a waiver of your final month's rent. The just cause reason for evidence of check 1, family moving in. Second, withdrawal from rental market. 3, demolish, remodel. Comply with government agency. Comply with government agency. This meaning which reason he should be out. Meaning normally third one, demolish or removal. I'm gonna break this building and then build a new one in case 60-day notice we should do. I'm gonna the first one, family moving. I move all of them, my family. Second one, withdraw from rental market. No more rental. I'm not gonna do. Third one, demolish, remodel. Remodel, I'm gonna build new build this building. Comply with the governmental agency. Government agency meaning this building should do for example, this building you need somewhat some reason should do government order should repair. If you do not vacate in the premise by the date stated in this notice, the landlord may initiate legal proceeding to regain possession. You may be liable for costs associated with the legal action, including any court reward damage. Landlord signature date, print name, address, phone number, email. There's a 60 days notice. 60 notice, which is the reason, what reason they have it. Why should I move it? I wanna live here, but no. That the no more this building in case we should give them that the 60-day notice. affidavit, affidavit of service. Affidavit of service, meaning proof of service, same meaning. County of Los Angeles, State of California, date, server, I declare on the penalty of perjury that a notice of eviction was delivered and serviced in the following manner. Recipient. The notice of eviction was delivered to defendant, respondent, address, location, date, time, AM or PM, delivery. The recipient received the eviction notice by mail. The server sent the eviction notice in the mail by standard mail, certified mail, FedEx, UPS, either. Normally standard mail is okay. We don't need for the certified mail or FedEx something. No, just the standard mail is enough. Direct service. The server handed the eviction notice to the person identified as the recipient. Someone at the residence. The server handed the eviction notice to someone who identified as living at the residence and stated their name is Mr. So-and-so or Mrs. So-and-so, doesn't matter. Someone at the workplace. The server handed the eviction notice to someone who identified to the recipient co-worker and stated their name is somebody. Living at the residence. The server left the eviction notice in the following area. Following area meaning door or floor, something at the nobody there. I dropped this paper. It's okay, that's legal. Recipient rejected delivery. The server delivered the eviction notice to the recipient in paper and did not accept delivery as some. In case you should remember, you can give the paper or drop the paper, doesn't matter. But even somebody wants some. I can. Verification. I declare on the penalty of perjury under the laws of located in this state that the foregoing is true and correct. Server signature, date, print name. Affidavit of service, meaning proof of service, same thing. After that, this 3-day notice or 6-day notice, even that date, tenant didn't pay, and then landlord should file for the summons with the notice. Summons. This page, today's page 5. Summons, eviction, unlawful detainer. Unlawful detainer for the meaning for the eviction. Notice to defendant. Defendant is tenant. You are being sued by plaintiffs. You are being sued by plaintiffs. Plaintiffs meaning tenant or manager, doesn't matter. Notice, you have been sued. The court may decide against you without your being heard unless you respond within 10 days. You have 10 days, not counting Saturday and Sunday and other judicial holiday. After this summons and legal papers are served on you to file a written response at this court and have a copy served on the plaintiffs. This one is changed. Past one is within 5 days should answer, but this time from this year, 10 days. This receiving this notice or summon after within 10 days did not answer should do. Lost the case, 10 days, not 5 days. If these summons are served through the Secretary of State safe at home address confidentially program, you have 15 days. You have 15 days from the date of service, not counting Saturday and Sunday, the judicial holiday, to respond. One more time. If these summons are served through the Secretary of State safe at home address confidentially program, you have 15 days from the date of service, not counting Saturday and Sunday and other judicial holiday, to respond. This one also changed. Summons are served through the Saturday and Sunday home address confidentially program. You have 15 days from the date of service. Any answer within 15 days. A letter or a phone call will not protect you. Your written response must be proper legal form if you want the court to hear your case. There may be a quote from that you can use for your response. You can find these quote forms and more information at the Self-Help Guide to the California Courts. Your county law library or the courthouse realist you. If you do not find your response for the courthouse, you may lose the case by the default, and your wage, money, and property may be taken without further warning from the court. There are other legal requirements. You may want to call on attorney right away. If you do not know that attorney, you may want to call on attorney referral service. If you cannot afford an attorney, you may be eligible for free legal service from a non-profit legal service program. You can locate these non-profit groups at the California Legal Service website. The Help Yourself Guide to the California Courts, or by contacting your legal coach or county bar association. Fee waiver. If you cannot pay the filing fee, ask the clerk for a fee waiver form. Notice the court has a statutory lien to waive the fee and cost on any settlement or had to be arbitration or $10,000 or more in a single case. The court lien must be paid before the court will dismiss the case. Right side is Spanish, you don't need it. The name and address of the court address. Two, the name and address, telephone number of plaintiff's attorney or plaintiffs without an attorney that one is also Spanish. You don't need it. Next page 6, plaintiff's name, defendant's name must be answered in all cases. An unlawful detainer is assistant. 4. Unlawful detainer assistant. Complaint if plaintiff has received any help or advice to pay from unlawful detainer assistance. A. Assistant's name, telephone number, street address, city and zip. D. County registration. E. Registration number. F. Registration expire on something. That's not important. Just the form only. Number 7. Okay, 10-minute break. We can go to the restaurant. It's meaning landlord. Plaintiff's landlord. Else cause of action against the defendant. Defendant is tenant. All the names should put right down. House, the husband and wife, the children, everybody name put right here. 2, a plaintiff is an individual of the age of 18 years. Yeah, over 18 years. 5 years, 7 years, doesn't matter, not including, over 18 years. 2, public agency, other, partnership, corporation. Plaintiffs meaning landlord or manager. B, plaintiffs has complied with the fictitious business name law and is doing business under the fictitious name of something. 3, venue is the court's name above because defendant's name above is in possession of the premise located at address. one more time I say that the premise meaning property. Number B, the premise is 3AR, property is 3AR, within the city limited on, name of city, within the unincorporated area, name of county. The premise in 3A were constructed in approximately year. 4. Plaintiff's interest in the premise is as owner, other meaning manager, or any other persons, agent. Plaintiff's interest in the premise is as owner or other meaning manager or agent. Number 5, the true name is the capacity of defendant sued, and those are unknown to plaintiffs. Those. That's. No, do not use the form of the eviction after sale. Something. Next page. Six, on or about. On or about meaning estimate date. Defendant name only. He is number 1. Agreed to rent the premise as a month-to-month tenancy. Month-to-month tenancy meaning every month, one time per month, he should pay the rent. Other tenancy, almost no other tenancy. One paid 2 months, or one paid after 3 months, something. Almost no, just a month-to-month tenancy. 2, agree to pay rent of $1,000 or $2,000, payable monthly. Any other person, almost 99% is monthly. Other, no. Payable monthly $1,000, or how much? 3, agree to pay rent on the first of the month. Almost every person is the first of the month. Other day, no special. Almost the first of the days of the month. B, this written or oral agreement was made with. You should make for the written agreement. Any agreement, rent agreement is written. Agreement was made with. Number 1, plaintiffs. 2, plaintiff's agent. Plaintiff's agent meaning manager or real estate broker, something. 3, plaintiff's procedure in interest, other. C, the defendant not named in item 6A. Defendant not named in item 6A, subtenant, assignee, other. Subtenant meaning for the I made the tenant with the owner, we getting for the 3 years lease, but I can leave the 3 years this place, just one year, and then I should move. In case we should find that the new person, if I find that the new person, I should pay totally this years. Subtenant. But subtenant meaning if he leave instead of me and he leaves 6 months after that, no, I should move it. In case the last of the period of 6 months, I should pay. That's a subtenant. Assigning meaning I should leave 2 years and then just 1 year I leave. But owner is agree. Okay, new person is come. New person is come, and then that's the assigning. Assigning meaning for I don't have any duty, if even he pay or not. Other. The agreement was later changed as follows. Agreement was later changed as follows. How we can change it? The first time is 2 years agreement, but the next day we change it just 1 year, 6 months, or 1 year. That one. A copy of the written agreement. Copy of the written agreement is attachment, including any addenda or attachment that from the base of the complaint is attached. And Label Exhibit A required the residential property unless item 6F is checked. F, for residential property, a copy of the written agreement is not attached because we don't have any written agreement. Why? Number one, the written agreement is not in the possession of the landlord or the landlord employees or agent, meaning we don't have any written agreement. Two, this action is solely for non-payment of rent. Non-payment of rent in case. 7, the tenancy described in 6 complete A or B. A is not subject to the tenant protection something. B is subject to the Tenant Protection Act. Number 8, complete only if item 7B is checked. Check all applicable box. A, the tenancy was terminated for all at fault, just a cause. B, tenancy was terminated for no fault, just a cause, something. Number 1, waive the payment of rent for the first final months of the tenancy. Waive the payment of rent for the final months of the tenancy before the rent came due under section is amount of something. This is the reason for why when he moved it, he paid deposit. If you pay deposit as the last month, need not pay the rent. This meaning, number 1, waive the payment of rent for the final months of the tenancy. Final months waived. I need not pay the final months before the rent came due under section 1946.2 D2 in the amount of how much I paying deposit. Normally 1 month's rent is $1,500, deposit is $1,500, or 2 months $3,000. I paid it deposit in case you don't need last payment, you don't need it. Somebody say even you paid the last payment and then after you moving, I returned it. No, you don't need it. I did not pay last payment. 2, provide a direct payment of 1 month's rent under section equaling to name each defendant and amount given to each. C. Because defendant failed to vacate. Because defendant failed to vacate, plaintiff is seeking to recover the total amount in A, B as damage in this section. Defendant name. You should remember, you don't need the paying, the last payment. Last payment is just a deposit. Waive the deposit. And then a lot of tenants say, anyway, you pay this month, and then after you move in, I return it. Why? I made a deposit. You don't need a deposit. You don't need it paying last month. Sure to remember, paying last month, that's deposit. The Philippine, you understand what I'm saying? Yeah, you understand, right? Yeah, you don't need to pay to the last month's payment.
Yeah, because there is a deposit there.
Yeah, but the landlord said,
Unless you want to.
yeah, anyway, you pay, I return it. Why I paid it, you return it? I didn't pay it.
Yes, because that what they want to do is they will deduct it from the wear and tear of that certain.
Yeah, they say for the cleanup, you should pay for the cleanup,
Yeah,
or you,
Repair.
the damages.
any damage, you should pay. No, you don't need it. Not paying the last month. That's the
So we are
right.
not obliged to pay the for example what we the damage that
Mhm.
what
Yeah, damage anyway. If you can get any damage, you pay. But then normally, what kind of damage? You break the wall, or you break the roof, or something.
Just a little scratch here, something.
Yeah, some scratching. You cannot.
oh okay.
And then, but if you bring for the dog or cat, in case you should pay the cleanup fee. They after you move in, just he say that the cleanup fee $1,000 and the damage $1,000, and then I made a $2,000 for the deposit. Just he say everything is the not waived. In case, no, you don't need it. If you pay, he not pay at the return the amount. Where should you go? If he didn't pay, you made him deposit and he didn't return it. In case, where should you go? Just to forget it. Hey, I have much money. To forget that. He didn't return the money. He didn't return the deposit. How you can do it? Two ways you can choice. One is you can file for the small claim and you can get a judgment. If not, you can apply to the, you should remember, consumer affair. You should remember consumer affair. Consumer affair, city consumer affair, and the state consumer affair. Doesn't matter. Normally, city consumer affair, you complain. You call 411. LA City Consumer Affair, they gave it the telephone number, and then I gonna complain for the landlord didn't pay for the deposit, and then you can do in internet. It's just a complaint form. Just a complaint form, 1 page or 2 pages, 1 or 2 pages. My address and name and telephone number, his address and name and telephone number, just to put right down. I made agreement, he and I, but even when I moved in, I made a deposit and he didn't return it. Just to put right here, and then they send a strong notice. Normally, any landlord within the return the money within 1 month, right away. If not, they should pay to the penalty. Just to remember, if you don't receiving the deposit, you should file for the complaint. Even consumer fair, even not just the deposit. If you go to hospital, if you go to the any action, that's not easy. To the in case complaint, any complaint, consumer fair should remember any complaint, consumer fair. You understand what I'm saying? Yeah. Defendant 9. 9 is right. 9. Defendant's name, defendant's me, was served the following notice on the same date in the same manner. Number 1, 3-day notice to pay rent or quit. 2, 30-day notice to quit. 4, 6-day notice to quit. 4, 3-day notice to quit. 5, 3-day notice to perform covenant quit. 6, 3-day notice to quit under Civil Code Section 7 other. Normally 3-day notice to pay rent or quit. Next page. Number 9, on date, the period stated in the notice checked in 9A expired at the end of the date. Defendant failed to comply with the requirement of the notice by that date. C, all facts stated in the notice are true. D, the notice includes the election of forfeiture. E, a copy of the date of the notice is attached to Label Exhibit 2, required to residential property, something. F, one or more defendants were served, number 1, with the prior required notice on the Civil Code, something. 2, with a different notice. 3, on a different date. 4, in a different manner as stated in attachment 10C, something. 10A, the notice in item 9A was served on the defendant name in item 9A as follows. Number 1, by personally handling a copy of the defendant to date. 2, by by leaving a copy with the name and description, a person of suitable age and the description on date something at defendant, residence or business. If you live at some place, your residence, and mailing a copy of defendant at a defendant's place of residence on date, because defendant cannot be found at defendant's residence or usual place of business. 3. By posting a copy on the premise on something, date, and giving copy of a person found residing at the premise and mailing a copy of resident a defendant at the premise on date. 8. Because defendant's residence and usual place of business cannot be ascertained, or B. Because no person of business, age of discretion can be found there. 4. Not for 3 days notice. See Civil Code 1946 before using by sending copy of certified or registered mail address or defendant on something. 5. Not for residents, tenants, see civil before using in the manner specified in a written commercial lease between the parties. B. Name was served on behalf of all defendants who signed a joint written rental agreement. C. Information about service of notice on the defendant as in item 9F is stated in attachment 10C. D. Proof of service at the notice is item 9A attached and label Exhibit 3. 11. Plaintiff's damage possession from each defendant because of expiration of a fixed terms lease. 12. At the time the 3-day notice to pay rent or quit was served, the amount of rent due was something. 13. The fair rental value of this premise, some per day. That's the so interesting. For example, you pay to the rent $2,000 per rent every month, and then 1 day. How much the 1 day? If you pay the rent $2,000, how much do you pay per day? Calculate.
$66.
How much?
66.
66? Yeah, every day is 66 per day. If you pay the $1,200 per day, $40. That's put right here. 13. The fair rental value of premise, some date. 14. Defendant continued possession of malicious and the plaintiffs entitled to statutory damage under Code Civil Procedure section, something. 15. A written agreement between the parties provide for attorney fee. 16. Defendant tenancy is subject to the local rental control or eviction control ordinance of City of County, title of ordinance, and date of possess. Plaintiffs has met applicable requirement of the ordinance 17. Other allegation, the state attachment 17. 18. Plaintiffs accept the jurisdictional limit, if any, of the court. Next page. Plaintiff defendant. 19. Plaintiff's request, meaning landlord's request. A. Possession of the premise. Return to my house. Possession of the premise. B. Cost incurred in the proceeding. Didn't pay amount you should pay. C. Past due rent. How much you pay, you didn't pay. D. Reasonable attorney fee. Normally, if you didn't pay to the rent is $2,000, just a reasonable attorney fee is $500 something. For the I didn't pay $2,000 rent, he said reasonable attorney fee $5,000. No, that's illegal. E. Forfeiture of the agreement. Yeah, normally agreement. F. Damage in the amount of waived rent or for relocation assistance as stated in item A. Any damage, if you find that any damage, how much you should pay. G. Damage at the rate stated in item 13 from date, something. For each day that defendant remain the possession through entire entry of judgment. H. Statutory damage of $600 for the conduct alleged in item 14. Other something. 20. Number of page attachment. Attachment is a list paper. List paper is 2 pages or number 2 something. Unlawful detainee assistance. 21. Unlawful detainee assistant normally did not. For compensation, give advice or assistance with this form. Here's the information: assistant name, street address, telephone number, county of registration, registration number expire on date, title, prince name meaning landlord, signature of the plaintiffs or attorney, verification, use a different verification from if verification is an attorney or for compensation of partnership. I am the plaintiffs in this proceeding and have read the complaint. I declare under penalty of perjury under the laws of the state of California that foregoing is true and correct. Date, name, signature. That's all. This is the unlawful detainer summon. If you didn't pay unlawful detainer, he filed this one is to the court, and then this paper is sent to you. And after that, after receiving this paper, within 10 days, you should answer. Answer is simple. Just I didn't agree. And after that, 1 month, just a court action. After that, you should move it. That even you didn't pay to the rent, don't worry. That's not easy to take them out. This one, they say today is strong, windy.
Yeah.
Yeah, be careful for the flying out.
감사합니다.
Okay,
Weather is good.
Hamida.
Thank you.
okay.
Thank you.